Hey guys, so here's part one of the appellate information for Scott Peterson. You guys will remember this case from April 2003. Scott Peterson was charged with capital murder of his wife Lacey and his unborn son Connor. The state's theory was that Scott killed Lacey at home between the night of December 23rd, 2002 and the morning of December 24th, 2002, suffocating her. In contrast, from day one, Mr. Peterson said he was innocent. I was going to go through the appellate information. It's quite lengthy, so this is just part one. The appellate information is some 470 pages. So to prove how and where and when the crime occurred, the state called more than 150 witnesses in its case in chief. The trial court commented on this evidence after the state rested, accurately noting the state had presented no evidence showing either how or where the crime occurred. So it looks like they're alluding to the state not meeting its burden of proof beyond a reasonable doubt. There is no evidence in this case how this crime was committed. There is no evidence in this case where it was committed. To its credit, the state did not dispute this finding. To the contrary, during closing arguments, the state itself went a step further, candidly conceding that it also could not prove when the crime had happened. And the prosecution said, "I can't tell you when he did it, I can't tell you if he did it at night, I can't tell you if he did it in the morning." Despite the undisputed absence of any evidence as to how, where, or when the crime occurred, the state asked a jury to convict Scott Peterson of murder and sentence him to die. Ultimately, the jury did just that. It is probably fair to say that there are not many cases in the history of California where the state obtained a guilty verdict and death sentence for murder absent evidence of how, where, or when the murder occurred. Nevertheless, Mr. Peterson does not dispute that there may be situations where a death verdict is warranted despite the absence of such evidence, but at the very least, a verdict under such circumstances raises a legitimate question as to how a jury could arrive at such a result. Here, the answer may lie in part in the community in which the case was tried and the manner in which the jury was selected. The Peterson trial generated an extraordinary amount of publicity. The trial judge noted that he had never seen anything like this case, and the prosecution itself conceded that this case generated more publicity than even the O.J. Simpson case. Hundreds of people showed up at the police station the night Mr. Peterson was arrested, many screaming "murderer." According to the police, their main concern was that Mr. Peterson didn't get lynched. More than 1,000 prospective jurors were subsequently called for jury duty. The jury voir dire showed that virtually every one of them had been exposed to publicity about the case. Nor was there any dispute that the publicity was extraordinarily prejudicial to the defence. Before hearing even a single witness, nearly half of all prospective jurors admitted they had already decided Mr. Peterson was guilty of capital murder. And in what may be a first for the American system of justice, outside the courthouse in which the parties would try to select a fair jury, a radio station posted this large billboard, which had a telephone number for people to call in and vote. The publicity continued throughout the trial. A mob estimated at more than 1,000 people gathered at the courthouse to await the guilt phase verdict. After the guilty verdict was announced, the 12 jurors departing to await the beginning of the penalty phase and decide whether Mr. Peterson would live or die were met with wild applause and cheering. Judge Girolami, the experienced Stanislaus County judge who presided over pretrial hearings, observed, "In my over 30 years in this community, I've not seen anything like the publicity generated by this case." Judge DeLucci, the trial judge and also a respected veteran jurist, agreed, "I've never seen anything like it before. I can't account for the reaction of the public to this case." And as noted, the prosecution itself acknowledged that the pre-trial publicity surpassed the Manson case and the O.J. Simpson case. Despite these observations, the trial court refused to change venue from San Mateo County. Thus, Mr. Peterson was forced to pick a jury in a community that had plainly been saturated with negative publicity about the case. But it got worse. Because of the publicity, the parties used a detailed jury questionnaire to avoid the voir dire process. Voir dire meaning to tell the truth. Over repeated and strenuous defense objection, prospective juror after prospective juror was discharged simply because they wrote in their questionnaires that they were opposed to the death penalty. No questioning of these jurors was allowed, even though every one of those jurors also stated in their questionnaire that they would consider death as an option in the case, notwithstanding their views on the death penalty. Instead, each of the jurors was discharged because, in the trial court's slated view, if you don't support the death penalty, you cannot be death qualified. As discussed in the following episodes, there are numerous reasons why the guilt and penalty phase verdict in this case must be reversed. This is according to the defence, not me. They include the fact that the state was not entitled to entrust the determination of whether a man should live or die to a tribunal organised to return a verdict of death. Yet that is exactly what occurred here, the defence says, when the trial court discharged juror after juror simply because if you don't support the death penalty you cannot be death qualified. They include the state's admission of expert testimony as to the movement of bodies in water, even though the state's expert candidly admitted he was not an expert in that area. They include the state's admission of highly prejudicial dog scent evidence, even though the dog had a dismal record of being wrong a remarkable 66% of the time. They include the exclusion of demonstrative video evidence offered by the defence, showing that the state's theory of how the crime occurred, Mr. Peterson dropping his wife's body, weighted down by 4 anchors, over the side of his small boat in San Francisco Bay, could not have happened without the boat capsizing. These and other issues will be discussed in much greater detail. Mr. Peterson recognises, of course, that he was not entitled to a perfect trial, but he was still entitled to a fair one. As the substantial errors catalogued in this brief illustrate, Scott Peterson received neither. Reversal is required. This is the statement of the case. On December 3rd, 2003, the Stanislaus Court District Attorney filed a 2-count information against appellant Scott Peterson, charging him with the December 2002 murders of his wife Lacey and their unborn child Connor in violation of Penal Code Section 187. January 9th, 2004, the state filed its notice regarding aggravating evidence. Trial was originally set for Stanislaus County. Prior to trial, Mr. Peterson filed a motion to change venue, alleging that prejudicial publicity about the case rendered a fair trial impossible in Stanislaus County. In its written papers, the state conceded that the pre-trial publicity has been geographically widespread and pervasive, but nevertheless opposed the motion. The trial court granted the motion over defense objection. However, the case was transferred to San Mateo County, only 90 miles away. Jury voir dire began in San Mateo County on March 4, 2004. The parties agreed on a jury questionnaire. After nearly 1,000 jurors had completed their questionnaires, the results showed that 96% of potential jurors had been exposed to publicity about the case, and of this group, 45% were willing to admit they had prejudged Mr. Peterson's guilt. On May 3, 2004, Defence Counsel made a second motion to change venue based upon the pretrial publicity in light of the information contained in the questionnaires. The state objected once again. This time the trial court denied the motion to change venue. Opening statements in the guilt phase began on June 1, 2004. The state rested its case in chief on October 5, 2004. The defence rested its case on October 26, 2004. The jury began deliberations on November 3, 2004. The jury returning with a request to see additional exhibits. The jury deliberated all day on November 8th and continued deliberating until lunchtime on November 9th. At that point, the court dismissed Juror 7. Deliberations began anew on that afternoon, November 9th, 2004. This second jury deliberated that afternoon and again the next morning until Juror 5 was discharged late the next morning. On November 10th, the jury began deliberations yet again. This third jury deliberated the remainder of that day. On the next day of deliberations, November 12th, 2004, the jury found Mr. Peterson guilty as charged in Count 1, first-degree murder, and guilty of the lesser included offence of second-degree murder on Count 2. The jury found the multiple murder special circumstances true. The penalty phase began on November 30th, 2004. The state's penalty phase case ended the next day. The defence case in mitigation began the same day and ended on December 9th, 2004. The jury began deliberating in the penalty phase that same afternoon. The jury deliberated all day on December 10th. Late the next morning, the jury sentenced Mr. Peterson to die. On March 16, 2005, the trial court denied Mr. Peterson's motion for a new trial, imposing a sentence of death. This appeal follows. Guilt phase. In December 2002, Scott and Lacey Peterson lived at 523 Covina Avenue in Modesto. All parties in this case agreed that on the morning of December 24, 2002, Scott drove from Modesto to the Berkeley Marina. The state's theory of this case was that when Scott left home around 10 a.m. that morning, he had already killed Lacey and he was taking her body to the marina to put in San Francisco Bay. The defense theory was far different. Lacey was alive when Scott left for Berkeley that morning, and Scott had nothing to do with the killing. The prosecution's theory thus turned on proving a single point. Lacey was dead by the time Scott left home and drove to the Berkeley Marina, and the state certainly acted consistent with this view, as Detective Brashini himself would later admit. Within days of Lacey's disappearance, police had already singled Scott out as the prime suspect. This explains why police collected and viewed much of the evidence in the case through a lens which assumed Lacey had already been killed when Scott drove to Berkeley that morning and focused exclusively on Scott Peterson as the murderer. But also fully discussed in future episodes, virtually every link in the state's evidentiary chain of guilt was fundamentally flawed. It was not just that the state failed to establish the time, place and manner of the killing. More to the point, the evidence the state claimed conclusively established Scott's guilt was simply unreliable and should never have been admitted in this capital trial. Thus, the state relied on expert testimony to support its theory of the case. The state introduced expert testimony on dog scent evidence purportedly detecting Lacey's scent at the Berkeley Marina where Scott had launched his boat on December 24th, and told the jury that if they believed this evidence, then he's guilty, as simple as that. The state introduced expert testimony about the movement of bodies in water, purportedly to prove that the conjunction of where the bodies were found and the prevailing winds and tides established the bodies must have originated from the spot Scott said he had been fishing. Once again, the prosecutor told the jury that if it believed this evidence, then that man's a murderer. It's as simple as that. But as the American philosopher Alfred North Whitehead puts it, simple solutions seldom are. The state bet its case on these experts, telling the jury that if they were believed, Scott was a murderer. In this singular respect, Mr. Peterson agrees with the prosecution. Mr. Peterson agrees that in the context of the evidence before the jury, the significance of these experts to the outcome of this case cannot be overemphasized. The facts of the case set forth below provide the court with that context, against which the court may itself evaluate the significance of the erroneously admitted evidence.